Thursday and Tuesdays on the off chance that I get to see you.
Hey, she wins. No. Your name, ma'am? Thank you. All right, what are we doing?
Our attorney is going to be discussing money on and for the negotiations.
Gotcha. Probable cause conference, April 24th, 2025, 9 a.m. Bond continued.
Yeah, just volume.
Yeah, go
You
ahead.
said I was winning, so.
Yeah, but that could change real fast. Go ahead.
Your Honor, Ms. Moses has no prior assault criminal history. She is not a flight risk. She does have a stable home to live in Jackson with her mother. We also will provide her transportation to make further court proceedings. We are asking for a PR bond in this matter. We have no objection to any testing or any other conditions imposed by this court, including the GPS tether.
Response.
Your Honor, the defendant currently has 2 holds out of Kent County. One for OWI, she was convicted of in 2023, or OWBI, excuse me, where I understand she still owes money on, and another for a child support warrant. The defendant also does have assault criminal history. She was not convicted, but she was charged last year with a domestic violence case that was ultimately dismissed. Furthermore, in this case, the defendant is alleged to have stolen packages and has sent, or is alleged to have sent, a letter admitting to and apologizing for the same to the victim in the case. There is an offer that has been extended to allow her to plead to a misdemeanor for days restitution up front. But I told defense counsel, given the fact that she has a warrant for not paying child support, she has a warrant for not paying her fines and costs on the OWI in Kent County, she has a residence in Jackson County and is here in Washtenaw County where she was previously living, stealing these packages. I am not convinced that she would come back to court, nor am I convinced that if she were to get out of custody, the victim would ever see the restitution in this matter if it's not paid up front. So I am requesting the court continue the bond as currently set, finding it to be appropriate.
But how's she going to even have a shot at trying to get restitution if she's incarcerated?
And defense counsel told me this morning that her mother will be helping her make those arrangements and that she is going to be using her tax monies.
And Your Honor, if I may, you make a very valid point, which I would like to emphasize. My client does need to get out of jail to secure employment and to start paying off all those fines and costs that she needs to pay off. And federal tax day is coming up next week. So on April 15th, so if she's here and can't pay that off, that adds to it. And Ms. Moses did make clear to me that she does plan on securing employment and her mother will be taking her to the court proceedings moving forward.
Where would she reside if she were out in Jackson?
Jackson.
So all of her holds are financial holds,
Yes, ma'am.
right?
I do believe that the child support is a child support case related to nothing.
Got it. I'm going to modify the defendant's bond, grant the defendant's motion. I'm going to modify it to a $10,000 personal recognizance bond. Defendant must be placed on a GPS location only tether prior to her release.
And good morning, Your Honor. Robert Allen, on behalf of Fitzgerald in case 5072. We need.
Okay, where's my second ruling? Oh, no, saunter up. We'll wait.
Assistant Public Defender Thomas Care, I can really hear on behalf of Mr. Fitzgerald.
Your Honor, I want to start by thanking you for passing this case earlier and allowing us this time.
All right. Have you seen the community corrections violation report?
Yes, we have, Your Honor.
you're doing on this today?
Your Honor, as far as my case itself, I'm asking for an adjournment. I was disappointed yesterday, and there'll be time to obtain discovery. You'd like us to address the violation, we can go right into that.
Go ahead.
So, Your Honor, the test on April 2nd was my client's first test. He also has a case out of Livonia that he actually tested for yesterday and tested clean. He says that he will test clean today.
Do you have those results?
We do not, Your Honor. I didn't have an opportunity to call Livonia. It's on-site substance abuse testing here in Washtenaw County. We can absolutely reach out to them. He states that he did not sign a release of information, but it seems like he was confused, Your Honor, because of his testing obligations in the Livonia matter. He didn't realize that he would have to be simultaneously testing. I told him that he could sign a release.
How long's he been testing in Livonia?
That was my second
What was your second week?
yesterday. Yes, second test.
What do you have as his appointment, Jay? Trying to find this.
Yeah.
Well, I have his arraignment date is March 31st. I have a test on April 2nd with a report on April 9th that he's positive. He was instructed at the time of arraignment he's not supposed to be using drugs. He's positive for fentanyl, cocaine, opiates, and amphetamines.
Your Honor,
Also, as I'm to understand that at the time he tests positive for these, he's also not supposed to be using narcotics from his order out of Livonia. So you'll be in violation in that case also. Go ahead. You wanted to say, Mr. Allen.
well, Your Honor, I think with his arraignment on the 31st, I do know I'm not a scientist, but we know that sometimes it takes some time for drugs to get through the human body and out of the system. And as I said,
Is he going to tell me that that he did not use after the 31st?
he says he did not use after the 31st. Again, that test, the positive test was on the 2nd.
When did he test in Livonia before that?
I couldn't tell you the exact date, but it was around the same time. It's the second.
Your Honor, if it helps to establish the timeline, Mr. Fitzgerald would have been arraigned on his OWY out of Livonia on February 4th of 2025. He then, his next appearance in that case was with the entry plea on April 1st. I'm assuming that he was transferred there after being arrested on this matter, which obviously occurred the day prior to that. And controlled substance possession is obviously one of the charges here.
So what makes me think if he was in violation of Livonia's order, say he's not going to be in violation of mine, because he is in violation of mine. This one.
Your Honor, all I can ask is that you give him a chance to show you that he can follow the rule.
And I'd like to add also that if we can, I don't know what the conditions for his Livonia case would be, especially now that he has entered a plea. But I know that here, obviously, we've got outpatient treatment, we've got CCOP, we've got some inpatient options. Clearly, substance abuse is an issue at this point. He says that he has been trying his best. He reports that he would be clean today. We don't have the results from the other test yesterday, but hopefully those are also had different substances, Judge. So we asked him if he might at least have the opportunity to get an evaluation or assessment to see if we can fit him for any type of treatment program.
Anything else you want to say?
No, Your Honor, just that you give him a chance. Like I said, he can, like co-counsel has said.
Well, let's do this. You can get a release from him. I want those Livonia results because something's not quite adding up. He's, and it's not like it's one drug. He's got a whole cocktail in him when he comes here to testify or comes here to test. So I'll adjourn his probable cause conference to next week, the 17th, 2025 at 9 a.m. And I'll just say this, I also am not believing, given the basically shelf life of some of the drugs in his system, that he didn't use after I am not convinced that he didn't use after he was arraigned. So at this time, defendant's bond is revoked. And you guys can get a release of information from him and make a determination as to getting those test results to me, and I'll take another look at it. All right, what are we doing?
So today's the date and time. We've adjourned this a couple times. I did file a motion for discovery. There was one set of medical records that were provided, though not the ones that I actually requested. I'm not wanting to fight over discovery at this stage, Your Honor, and without giving up my right to get those at a later date in circuit court, if it goes there, I think we should just try to get an exam date.
I'm not setting an exam date if discovery is not complete, because then you're going to get to exam. Somebody's going to say, well, I don't have this and I want an adjournment. So we're just going to do it here. What do you need?
So there were 2 hospitalizations that I had advised the government of the people on. There was a Mott hospital in April of 2024. And then there was a IHA hospitalization. Actually, both were in Mott Hospital, 4/24 and 6 of 2024. So that's what I'm looking for.
Yeah, Your Honor.
Yes.
Your Honor, and I want to just make a record some of this. Mr. Margolis already knows I've been sitting in on this case a few times. I'm somewhat advised in communications with Ms. Reiser, but not fully. So I'll make the record as best as I can. Last time I spoke to Mr. Margolis, when I stood in on this case, I asked him to be very specific about what records he needs and to communicate that to Ms. Reiser. He may have done so, he may not have. We may have different definitions of what specific is. At this stage, I would not feel comfortable scheduling an exam until I know, especially with the record that was just made by Mr. Margolis, that he has everything that he is entitled to for this case. So I again encourage him to be very specific. By specific, I mean exact date, exact report he's looking for, and to communicate that to Ms. Reiser.
I have no
And
problem.
if you could please have it determined. Thank you.
Sorry, I have no problem.
I remember this coming up the last time. Did you send those dates to Ms. Reiser?
So I sent an email to her office on October stating Trinity and U of M emergency within the last year on 2 occasions, but I did not send those specific dates.
Okay, so that may be our problem. So are you going to do that now?
Of course.
Okay.
That will solve it. Thank you, Your Honor.
So let's just put this over. Continue. Thank
Thank you,
you.
Judge. Always a pleasure.
All right. Yep. Take care.